89.3 4CRB.
And a very good morning to you. This is John Fradgley from the Bell Legal Group, back with you for another program of The Law and You. This is your opportunity to get free legal advice between now and 9:30. All we need you to do is get on that telephone. 55208888 is the number. That number again, 55208888. And as we say each week, if you're south of the Tweed River, don't forget to put 07 in front of the number. Also, we have our email that you can send questions through to if you're not able to call during the time the program's on. We'd always like those emails to come in a day or two before the program, as it's not really possible to deal with emails that come in during the program. But if you have a question and you know that you're not going to be in a position to call on the day or today during the program, you can email that in to talkback@4crb.com. So that is talkback, all one word, at 4crb.com. And speaking of emails, we did get an email late last Tuesday from Brian, who said that his ex-wife, who is 84 years of age and living alone, or living on the Gold Coast, has just taken her nephew, who's aged 50 and single, who's been living in various accommodations since he left school, taken him into her home. His brothers and sister will have nothing to do with him, and he's extremely careless with the truth. And what he's concerned about is that if the nephew is still living in the house of the ex-wife after she passes away, would there be any trouble getting him out? The house is going to be left to other people who may want to sell or rent it, and Brian is concerned that the nephew will try anything to try and remain in the house and basically cause trouble. So the situation is that it may depend on the circumstances existing at the time that Brian's ex-wife passes away. If, for example, the nephew was made the executor of the will, or alternatively, if he's paying board and lodging to the ex-wife as a tenant or as a boarder, then it may be a little difficult to get him out. It would be particularly difficult to get him out if he, in fact, was made the executor under the will and the house was left to him, because obviously there would be that would completely overrule the whole thing. But assuming that that he is simply living in the house, not paying any board, then he would be regarded as a tenant at will. But there is still a process that needs to be gone through under the Neighbourhood Dispute Resolution Act, which in Queensland took over from the Residential Tenancies Act, that where notice would need to be given in order to evict him from the property. And indeed, we're in our office going through that exact process at the present time in a rather complicated matter, where one of the beneficiaries of the will has in fact been living in the home and has been making it extremely difficult to get rid of them. But nonetheless, there is a process there, and the law will take its course. And despite the fact that often the wheels of justice do move rather slowly, ultimately, assuming that the will made by your ex-wife Brian continues to leave the property to the other parties, and this nephew is not included, then it shouldn't be a hugely difficult task in order to get rid of him. The other thing too, last week I think it was Joanna rang in and we were talking about codicils to wills, and Joanna was saying that she and her husband had made wills which they had amended by codicil at a later stage, but they now wanted the wills in their original form, and she asked whether they could simply destroy those codicils and whether that would leave the will in its original form as the last will. There will always be a shadow of doubt in that situation, and as I suggested to Joanne last week, the safest thing you could do would be to go and see your solicitor to just look at exactly what the codicil says and what would be the implications of its destruction. So that would remain my advice. However, obviously a codicil could be destroyed by destruction or revoked by destruction, and one of the other alternatives would be to re-execute your will. So in fact sign it again and redate it and have it re-witnessed by two appropriately independent witnesses with the date appearing, so that there is a clear intention that you intend to reinstate that will in its entirety. That will obviously indicate that there was some other subsequent document which may be then investigated. So all in all, I think the best thing to do would always be to probably redo the will completely, just so that you put it all beyond doubt. But as I say, destruction of the codicil would be one option, and if you did destroy the codicil, you could leave a note saying that the codicil was destroyed with the intention that the will in its original form would continue to apply, but that would still leave some uncertainty. So, Joanna, my advice remains that you should go and see your solicitor in relation to this and just get it sorted out as best you can, so that there's no likelihood of any problems when you ultimately pass away. But enough of that. We don't presently have any callers online, so if you have a question or a query this morning for the law and you, get on that telephone right now. 55208888 is the number. That number again, 55208888, and we'll be back after this word from our sponsor.
Have you got old jewellery, coins, banknotes or stamp collections just taking up space and collecting dust? You need to speak to our trusted sponsor, Jeff Yates. Jeff will give you the very best price for your unwanted collections and jewellery, and will even come to you in the privacy of your own home. Jeff has over 35 years' experience in this business. Call now on 0412 11 32 11 to arrange an appointment to give you the best price.
Are you serious about losing weight? Vitadiet has been helping Australians lose weight and live healthier since 1987. All Vitadiet shakes, soups, bars and desserts are gluten-free, made in Australia, and have been perfected over 30 years. There is a Vitadiet eating plan, and yes, you do eat real food. Plus, use the Vitadiet ketone sticks to gauge your fat-burning performance. To find out how you could lose up to 3 kilos in your first week, visit vitadiet.com.au for your local pharmacy or call 1300 Shakes. Vitadiet. Time to try it?
Our sponsor.
And this is the Law and You on 4CRB. Our telephone number 55208888. That number again, 55208888. Rather slow morning this morning, like last week really. We didn't have any calls for the first 10 minutes or so of the program, and then we had an avalanche of calls in the second half. So if you have a question or a query, you could be our very first caller this morning if you get on that telephone right now, 55208888. Another issue that we've been looking at in the office recently in relation to estate administration is the question of capital gains tax and its possible impact after a person passes away. Now, obviously, if you own investment properties and you pass away, if they were purchased post-September 85, then they are under the capital gains tax regime, and therefore anyone who inherits that property, if the property is left to them under the will, they will inherit the same cost base as the deceased. However, if the executor sells the property, then that will trigger a capital gains tax liability at that point, because it is a post-September 85 asset. So that is just something that you need to be a little bit wary of. But enough of that for the moment. We've got our first caller online this morning as we say hello to Jim. G'day, Jim. How are you?
Too bad, mate. Yourself? It's about my son had a run-in with a cab. He ran the back end of him, and he the guy's trying to get him for loss of income.
Right.
And he's also, he didn't give Timmy any quotes. He just sent out the thing from his lawyer.
Mm-hmm.
And I just wonder, like, where he stands on that sort of, like...
Yes, well, does your son have insurance at all?
Yeah, only the third party.
Well, he should hand it over to his third-party property insurer, because the third-party insurer will deal with those issues for him.
Oh, right, yeah. Well,
Yeah.
they said that they don't cover damage to the vehicle. It's just if anyone in the vehicle's injured.
Oh, well, that's not third-party property damage. That's only his third-party insurance, which is the insurance that comes with your registration.
Oh, right, yeah.
Yeah, so he's basically liable for the damage to the vehicle, and it very well may be that there is a claim for loss of income, and that's going to be an ugly fight, I must say. Does your son live on the Gold Coast?
Yeah,
Which part of the Gold Coast does he live?
Southport.
Okay, look, what I would suggest you do, I would suggest that he ring the what used to be called the Citizens Advice Bureau. It's now called the Gold Coast Community Legal Centre and Advice Bureau, which is located in Southport. Have you got a pen handy there?
I do, actually, yeah.
Yep, so their number is 5532 9611.
5532
9611.
9611. Yep.
Yeah, now they're located in Railway Street at Southport. What I would suggest your son does is give them a telephone call and make a time when he can go in and see them and get some advice in relation to what's happened and the best course of action for him to follow in relation to it.
Yeah, that's cool, mate. Yeah, thank you heaps for that.
Okay, no trouble
All
at
right,
all,
thank
Jim.
you.
All the best.
Have a good day, mate.
You
Take care.
too. Cheers now. Time on 4CRB is just coming up to 18 minutes past 9. The Law and You is the program, 55208888 the number, as we say good morning to Judy.
Good morning. I would just like to know the role of an executor, please.
Right, okay. Well, the role of the executor, Judy, is to basically administer the will according to its terms. So the executor's responsibilities start from the time that a person passes away. If someone had a power of attorney, then the power of attorney looks after their affairs if they are unable to do so themselves up until when they pass away. But as soon as they pass away, the powers of the attorney cease and the executor's role steps in. So depending on the family circumstances, the executor's role even extends to the organisation of the funeral in the first instance. However, from a practical point of view, if the executor is not a member of the family, then normally the executor will leave it to the family to organise the funeral. The next thing that the executor has to do is to make sure that they secure the assets of the estate. So, for example, if there was a home, to make sure that the property is secure, to check as soon as reasonably possible to ensure that there is insurance in place, to then, depending on the nature of the assets, it very well may be that the executor has to apply for probate of the will, which means applying to the Supreme Court, basically for an order that the court says, after due investigation, the court is satisfied that this document is the last will and testament of the person. And that will depend on the value of and nature of assets in the estate. So as a rough rule of thumb, if someone has a bank account with more than $50,000 in it, if they hold shares in public companies, then in Queensland you would need probate. If they are in a nursing home and they've paid a residential accommodation deposit, then 99% of nursing homes require probate to release the RAD. If it's New South Wales, even for the transmission of a property, the executor is required to obtain probate of the will before they can deal with the property. It's then up to the executor to deal with the assets in accordance with the terms of the will after paying all of the liabilities of the estate. All right then?
Thank you. Yes,
Okay.
thank you very much.
No trouble at all. And the time just keeps rolling along, 20 past 9 as we say good morning to Joanne. Good morning, Joanna. How are you?
I'm good, thank you. How are you?
Very well, thanks.
Good. John, I've got a question. I've got a 20-year-old daughter who's just, she'll be finishing university next year.
Sorry, how old is she?
She's 20.
20, right?
Yeah. And what I was aiming to do is try and get her on the property that I was looking at getting a little investment property, ideally in her name, but I saw a bank recently, and she's not earning yet, and I'm putting the finances, it would have to go into both her and I's name.
Yes, you're breaking up a little bit, Joanna, on the phone. But just to recap, so your daughter is 20, she's going to uni next year, and you're thinking of buying an investment property for her to live in, is that right?
Yeah. It would be in her and I's name, but I was just wondering would it be beneficial to create a trust? Right,
okay. Well, look, if you put the property in her name, partly in her name, bear in mind that, and I assume she's going to live in the property, is she?
Yes.
Okay. Well, bear in mind that if you put the property partly in her name, then that will be regarded as her first principal place of residence. And so therefore later in life, if she was to marry and her and her husband purchase a home, she very well may be excluded from the first principal place of residence concessions that are available in relation to stamp duty, etc. If she's living in the property, then that half of the property would be exempt from capital gains tax on sale of the ultimate sale of the property. However, your half of the property would not. If you put the property in a trust, then it would basically be regarded virtually completely as an investment property, unless your daughter could claim that as a beneficiary of the trust, she's living in the property as her principal place of residence. And depending on the value of the property, you would just want to be careful that the unimproved capital value of the property did not trigger payment of land tax. So there would be a number of options for you in this situation, Joanna. I would probably recommend that you might be best to go and see either your accountant or your solicitor, or both actually, in relation to what you may do. One option for you would be to buy the home in your daughter's name, and you could put a mortgage over the property. Are you going to have to borrow to purchase, or will you be able to pay cash?
No, I have to borrow.
Oh, right, okay. So you wouldn't. So if you may or may not be able to put the property in your daughter's name, but if you did that, then you would get the first principal place of residence concessions for your daughter, and then when the property was ultimately sold, the capital gain on the property would be tax-free, and you may be able to, for example, put a second mortgage in place for the money that you put in, if you're going to put in any money yourself. So there are a number of options available. Before you made any decision, quite honestly, Joanna, I would recommend talking to your accountant about it, the best strategy from an accounting and a tax perspective, and then after that I would be talking to your lawyer about the best structure or method of purchase that you may be able to put in place, whether that be in your daughter's name with a mortgage for the balance of the equity in the property, or whether you buy it in joint names and realise that there will be capital gains tax on part of the property ultimately when it's sold. All right then?
Oh, lovely. Thank you so much for that.
Okay then, Joanna. All the very best. And we'll be back after this word from our sponsor.
Now is the time to have your skin checked. Tweed Skin Cancer Clinic has been treating patients for over 20 years. All doctors are trained by fully qualified plastic surgeons for treatment and dedicated aftercare, and they bulk bill. They have the highest pickup rates for detecting skin cancer and melanoma in the country, and even visit nursing homes. Open Monday to Friday 9 to 5 and Saturday till 3. Phone our sponsor on 5536 4961.
Harvey Norman bonus Wolf Blast wine offer. Spend $399 or more on selected electrical products in one transaction and receive a bonus 12-bottle case of Wolf Blast Silver Label wine valued at $300. Or spend $1,500 or more and receive an additional bonus case of Wolf Blast Silver Label Sparkling Brut. Choose from a range of washers, TVs, fridges, audio coffee machines, vacuums, dishwashers, cooking and small appliances. Bonus via redemption. Great electrical deals plus bonus Wolf Blast wine offer only at Harvey Norman, South Tweed.
Another sponsor.
And the time's just coming up to 25 and a half minutes past 9. We've probably got time for one more very quick call, if you want to get on that telephone now. But while we're waiting for that, you may remember I was talking at the start of the program about capital gains tax and the unlikely consequences around capital gains tax concerning the death of people. One of the other things to bear in mind too, I was talking about investment properties, is that if a husband and wife own an investment property in their joint names, which was a pre 85 asset, so in other words an asset owned prior to the introduction of capital gains tax, and then one of the two parties pass away after the introduction of capital gains tax, then the share of the property that has been inherited by the surviving joint owner of the property will, in fact, the half share that has been inherited will be subject to capital gains tax when the property is ultimately sold. So if you have a situation where, for example, mum and dad owned a house as joint tenants, which was an investment property which they purchased in 1980, and then dad passes away in 2000 and mum passes away in 2010, then mum's half of the property will be exempt from capital gains tax, but dad's half of the property is going to be subject to capital gains tax for any increase in value from the time of death until the time the property is sold. So it underscores the fact of how important it is to keep good records in relation to the purchase of properties and these events, because in that situation it may be necessary to get a valuation done on the property as at the date of death of dad, so that you can show or prove what the capital gain was, and in order to bring that properly to account. The other area too where you need to be aware of the perhaps unforeseen consequences of capital gains tax is if a property is left to an overseas resident, so someone who is a foreign resident, that is automatically subject to capital gains tax. And in fact, that doesn't matter whether it's an investment property or the principal place of residence. So you do need to be extremely careful in that area of capital gains tax and property when someone passes away. So just a couple of little things to keep in mind there. Well, that's probably all we've got time for this week, so I'll look forward to being back with you again next week when we can... we've just got a very quick call. We'll just try and deal with this. Robin, good morning. Robin, are you there?
Yes, I am.
Yes, how are you, Robin?
Hi.
We'll need to be quick.
Thank you. Am I already on air, John?
You are indeed.
Oh, indeed, thank you. I'll be as quick as I can.
Sure.
When family members of a deceased auntie are the executors of an estate, or even if it's not family members, are there not some obligations to keep beneficiaries relatively informed over a period of months of what's happening, what the unit's being sold for, any adjustments just every few months?
There's no legal obligation, but certainly as a matter of common sense and a matter of courtesy, that should be done to keep people aware of what's going on. There is a thing called the executor's year, which basically is the period of time within which an executor should reasonably be able to deal with the administration of an estate. And in relation to specific bequests, for example, of cash, if they've not been distributed within that 12 months, then the beneficiaries are entitled to interest on the money from that time. So particularly in circumstances where you believe the executor is not dealing with the administration of the estate, then that's a circumstance in which it may be appropriate for beneficiaries to get legal advice, where, for example, the executor has simply done nothing. We're dealing with an estate at the moment where the executor didn't even advise the beneficiaries that they were beneficiaries for 6 years. And they became aware by chance, and now, as you can imagine, all hell has broken loose. So,
of course, John,
so yes, I think that an executor, as a matter of course, should make sure that they keep the beneficiaries informed of particularly when the beneficiaries make inquiry.
Thank you. That was the final wrap-up, John. If you've actually sent an email asking basic questions courteously and been ignored, surely there's an obligation, or is it, again, common sense and courtesy but not a legal obligation to be answered?
That's right, but it may, depending on the seriousness of it, it may give rise to circumstances in which you could bring an application to the court to have the executor removed. So normally in that situation where they're not responding, I would write a couple of times, and if they still fail to respond, I think I would write and say, look, unless you provide the information requested, we will need to consider making an application to the court and seeking an order for costs against you on an indemnity basis. Okay then?
Thank you so much,
Robin,
John. I really appreciate this, and for CRB.
Thank you very much. Bye now.
All the best.
John Fradgley from the Bell Legal Group. Until next week, goodbye and God bless.